Mugera joined the co-accused of Kawempe North Member of Parliament MP Ssegirinya and Alan Sewanyana for Machinge West in the Greater Masaka murders wants court to grant him bail. At the International War Crimes Division Court in Kororo, presided over by Lady Justice Alice Komuhanji Kauka, Mugera presented three sureties, Deo Chisasa, Mary Bilungi Namaga, and Annette Sanyu, his wife, for court to grant him bail.
In this application, the applicant has not brought any different information from that was presented to this Honorable Court earlier in the previous two applications. Therefore, Your Honor, I pray that this Honorable Court strongly finds in the favor of the applicant that he has a fixed place of abode. Your Honor, it is laughable and quite confusing on the guts of counsel. Okay, Your Honor, my apologies, Your Honor. Your Honor, this is the third time the applicant is applying for bail before this Honorable Court. And Your Honor, in your decision, miscellaneous application, criminal miscellaneous application number 2 of 2023, number 2 of 2023, Your Honor, in your judgment, in your ruling, I beg your pardon, you confirmed that the applicant has a fixed place of abode by virtue of the charge sheet, which my senior learned colleague is the custodian of the same, and the charge sheet does confirm that the applicant is a resident of TMB, Machinge Division, which has not changed to date, Your Honor. And the same is still supported by the letter. My Lord, in the same judgment, the charge sheet confirmed the place bears, and also the national ID, Your Honor, which has not been disputed. The national ID of the applicant does confirm his fixed place of abode with TMB.
Mugera also informed the court about his health status, which requires him special treatment outside prison.
It is my submission, Your Honor, that there is an exceptional circumstance for the grant of bail for the applicant. Your Ladyship, on the application of the applicant, there is a medical report. Your Honor, my learned colleague submitted that the medical report states that the situation is manageable. The situation of the applicant is manageable. But it is our submission, Your Ladyship, that managing a situation of a disease or illness does not amount to curing the same, Your Honor, to which the applicant is seeking bail application, is seeking to be released on bail so that he can go and be treated better. Not just to be managed, Your Honor, not merely to manage his situation. And of which my learned colleague has not disputed to the fact that indeed for 2 years the applicant for 2 years has been suffering from hypertension. Be that as it might, Your Ladyship, I'm concluding my point. It is well stated in a plethora of authorities that furnishing exceptional circumstances is not the sole consideration for application for bail. In other words, my Lord, it has been held that court can grant bail in the absence of exceptional circumstances, Your Honor. This has been held in the case of Dr. Ismail Kalule, the learned brother, versus Uganda, criminal miscellaneous application number 1 of 2018. Criminal miscellaneous application number 1 of 2018. Your Honor, on page 13. The same position, Your Honor, is echoed in the case that I've already adduced to this Honorable Court. Nicholas Opio, Your Honor, wherein they cited case of Human Rights, Foundation for Human Rights Initiative versus Attorney General. Constitutional Appeal number 3 of 2009. The same position, Your Honor, was affirmed that this Honorable Court can still grant bail to the applicant in the absence of exceptional circumstances, Your Honor. And still it was reiterated that as long as the applicant proves that he will attend to court when trial is due. Your Honor, I go to the second point of the applicant having a fixed place of abode. Our humble submission, Your Honor, this Honorable Court should exercise its discretion and find that the applicant has proved all grounds of his bail application and grants him bail so that he can enjoy his right of liberty.
Prosecution objected to the application on grounds that the accused failed to clearly prove to court his place of abode. The same with his sureties.
If the court is to believe that the applicant has a shop, that the applicant has a bar and a lodge in Chotera, vis-a-vis. My Lord, the suit is presented. I will start with the first one. That is the wife, my Lord. Sanyu. My Lord, Sanyu says they stay. She stays in Chibuye, in Chibuye 2 parish, Machindia, and they introduced her, my Lord, and yes, my Lord, Sanyu. But I don't understand the name that first of all is on that introduction letter, my Lord.
Sorry?
When you look at, I refer to C3 of the application. I don't understand that name.
You don't understand?
That name.
Which one?
Which on C3, my Lord? I beg counsel to maybe inform us.
Your Ladyship, that name there is Sanyu Anet, and Your Ladyship, Sanyu Anet is still in court. I pray that if my learned brother wants to inquire more about the letter, she's in court. You can apply for cross-examination and examine her on that.
Mr.
Yes, Your Ladyship.
Look at it and tell us what it is.
Your Honor, this
that you're relying on.
Your Honor, this is a you, but as if the person who was writing first wrote and wrote.
So what are we supposed to? Isn't it your responsibility to avail of an accurate copy of whatever you intend to rely on?
Your Ladyship, it is my
Because
responsibility.
the document should speak to itself, isn't it?
Yes, Your Ladyship.
But
But besides that, my Lord, I would refer you to the content. He or she is a duly registered Ugandan with good behaviors, law-abiding residence without any criminal offense in the area. My Lord, it is not introducing her as a surety with a fixed place of abode.
no, the first part, read the first part.
Who is a resident of the above-mentioned village? Yes, my Lord. Only being a resident is not prima facie that you have a fixed place of abode.
Okay.
Residents are both permanent and temporal. So meaning she can be, I don't know how I can say, she can keep on migrating after 3 months, 4 months. And she's resident wherever she goes. She's a resident wherever she goes, but not a permanent resident. What is the definition of what amounts to what court would say residence, a permanent resident, my Lord? I have furnished the authority, my Lord.
Place of abode.
Fixed place of abode defines the residence of who a substantial should be in court. My Lord, we invite this court to find that she has not proven.
Your quarrel with Miss Sanyu is she doesn't have a fixed place.
Absolutely. And she's not worth a standing surety for someone. because even her tracing her will be a problem. So we'll have two burdens. Tracing for applicant in the case he absconds, and then the surety. We don't have those resources, my lord, to run after them. Surety number 2, who is a broker or border. Surety number 3, who is a charcoal vendor. Will these two, who are economically submissive to the applicant, be able to control him if he said he's in his business, so therefore he won't be in court on that day? Will they be able?
Your Honor, on the issue of control, counsel submitted that she will not have control over the accused person or the applicant. We submit, Your Honor, that she will have the control over the applicant because they all stay at the same place in Chiembe. They all stay at the same place, Chiembe, Your Honor. And counsel's submission, Your Honor, that the applicant that the suite number 1 cannot have control over him since he has businesses in Chota and moving back and forth. Your Honor, that can be cured by this honorable court when it sets stringent terms. When it sets stringent terms restricting the accused or the applicant from moving outside the jurisdiction of this honorable court.
Prosecution also objected to Magala's land title copy and the alleged guest house in Chotera presented to court by the accused on the ground that he failed to prove ownership.
Is it in order for this court to rely on the receipt, the trading receipt, to confirm that this gentleman, the applicant, owns a bar and a lodge in Chotera? Is this enough? My argument, my lord, and which will make this court to agree with the prosecution, is that he does not own. He does not. This is not proof, and as such does not own. My lord, there was also a purported land title. Yes, my lord. There's a purported land title, which is not marked. It is not marked. It is B3. It is B3, my lord.
My lord, I pray that counsel restricts himself from making disparaging remarks and misleading this honorable court, unless he produces evidence to the same.
You have most land title, B3. Yes, Mr.
Yes, my lord. My lord, this title is not certified. That's why I'm saying it is alleged. This title is not certified by the registrar of titles, so I'm right to say it is alleged. And I beg to proceed that this alleged land title is not proof that the applicant owns a lodge and a bar. And even if he owned a lodge and a bar, my lord, even if court is reluctant to agree that he owns a bar and a lodge, is it a prima facie that he has a fixed place of abode? These are questions, my lord, we invite court to answer in argument with the prosecution. That there is nothing, doesn't own a lodge, doesn't own a bar, and there is no fixed place of abode there. Then, if court is struggling with the prosecution that there is no fixed place of abode in Kampala because there has been no proof, and there is no fixed place of abode in Chotera, then is he worthy, my lord, releasing on bail? Where does he fall? Our argument is that he's neither here nor there.
My lord, counsel submitted on the issue of Chotera, the applicant. The applicant not, yes, Your Honor, Chotera residence, my lord. And the bar, he submitted the applicant. My lord, it is my submission that the applicant is the owner of the same by virtue of the trading license of 2023, and wish to add that the trading license Lord, it is on that is the A2, Your Honor. Yes, Your Honor. It's the Chotera Town Council trading license, which I proved to this honorable court. Your Honor, this is a trading license of 2023, which indeed proves to this honorable court that the applicant, who is the owner of that bar and guest house, which is currently being operated by his wife, that the same is indeed their property, my lord.
Maybe what you didn't bring out, which you may bring out, is the relationship between Kamuda, his house, and bar with the applicant. You don't bring it out because these are two separate.
Your Honor, we had submitted earlier and informed this honorable court that Kamuda and Kamuda Guest House and Bar, Your Honor, is a property of the applicant, which he was running before he was arrested.
I just want you to know where he
Yes, Your Lordship. Beg your pardon on that.
What is there to show? What's the nexus between Kamuda and Mr. Mugera?
And Mr. Mugera, he's the owner, Your Lordship. That's the
Give me
nexus.
evidence. That is what I'm going to ask for.
Your Honor, the trading license, which we
The trading license, the one you want me to consider in 2023, which is in the names of Kamuda, his house. And I'm simply trying to leave you somewhere where you can see it go. Unless you don't have evidence.
Your Honor, the charter receipt, town council receipts, and that certificate of title, Your Honor, which we attached.
Mr. Ssegirinya.
Yes, Your Lordship.
Let's look at the certificate of title. Is his name?
It is in the names of Mugera John. Yes.
And the trading license?
The trading license, Your Honor, is in the names of Kamuda Guest House and Bar.
So what evidence do I have that there is a relationship between Mr. Mugera John and Kamuda Guest House and Bar?
My lord, on that regard, the applicant never registered.
So now that is...
Never registered.
I expected you to do something bigger or more than what you did. Especially because I'm trying to look for the nexus between the land title and the trading license and the general receipts and rent. Yeah, the general receipt that's now part of D2, but earlier in the earlier application was AA3. It is in the names of Mr. Mugera, and then also the one, yes, the one of February 9, 2016, also in the names of Mr. Mugera, which is okay. And then when I come, I failed to get the nexus between these documents and the trading license, which is in the names of Kamuda, and that's the nexus I would like to bring forward for consideration.
Yes, Your Honor. I am referring this honorable court to receipt number
He also contested the financial stability of the sureties to stand for the accused and asked court to dismiss the application.
Referred it to page 3. Oh, yes. And my lord, I found issue with the ruling. My lord, in that case, among others, your senior brother Just Lameka N. Mukasa as he was then, ruled that it was very hard for a surety who was living in a different place with the applicant to control them. In this case, the surety was living in Wakiso and the applicant was in Kampala. So there would be issues in control of the applicant, and that was a ground upon which he denied bail. My argument in relation to the instant case is that whereas surety number one is a wife to the applicant, there is evidence that at times the applicant is in Chotera. Yes, but there's a shop, alleged shop in Kampala. Now, the issue is, what if the applicant is in Chotera and the surety is in Kampala? Would the surety still have control over the applicant? Our argument is no, my lord. And we invite court to agree with us. However, our argument would have been different had they stayed in one place. That is, if it is Kampala without Chotera. My lord, I will mention a few issues in respect to other sureties, then sum up with my authorities. In one or the other shows that a person, a surety, should have a credible source of income. Charcoal is not a credible source of income because even the president banned it. He banned the charcoal, my lord. So it is no longer business. Surety number two does not have the same kind of business, is not registered. Economical muscle than them. And what court would require here is a person of a higher economical muscle, financial muscle that can prevail over the applicant just in case, which is not there in this matter, my lord. My lord, I'm finishing up. Besides that, yes, my lord? Yes, my lord. Yes, my lord. Besides that, my lord, this is a matter which is very sensitive. It's a matter which is very sensitive, my lord, that it is for a person, for a person to be granted bail, my lord, he should have demonstrated that he will be able to return to court. And he demonstrates that through proving his place of abode, proving his sureties, and even proving any allegations he put across. Because the burden of proof is on the applicant, especially to prove exceptional circumstances. So you demonstrate your ability through that which the applicant has failed, my lord. My lord, this court, my lord, denied bail to some applicant, my lord. I'll beg to quote the ruling by Honorable Justice Alice Komuhani Kauka in miscellaneous application 17 of 2018, 17 and 18 of 2022. That is Bakura, Alex, and 48 others. My lord, I have a copy of the said ruling, my lord. My lord, in that case, my lord, I can refer you to this one, my lord. I can't quote a particular page, but I can temporarily refer you to page 31, of 31 of the ruling, my lord, where this court granted bail because of in a matter which almost had the same charges to applicants who had only proven exceptional circumstances. which have not been proven now. My lord, in that case, the applicants, the trial judge looked at the applicants and saw them as people of advanced age. And that is the reason as to why they were granted bail. And the reason for that is because the matter was sensitive in a nature that without those exceptional circumstances, bail would not be granted. We invite this court to invoke the same spirit in that ruling, my lord, or that case, and deny the applicant bail in this case for failure to prove.
Judge Alice Komuhanji Kauka set 28 September 2023 to deliver a ruling. The accused Mugera John was remanded to Luzira prison. Meanwhile, the same court has indicated 1st September 2023 to deliver a ruling of confirming charges against the 8 suspects accused in the murder of Major Muhammad Chigondo. Registrar Tim Beatrice presided over the case on the behalf of Justice Richard Wawire. In another development, High Court Civil Division in Kampala has set 23rd October 2023 to start the hearing of the case filed by Sam Mukala against Pastor Jackson Senyonga of Christian Life Church Ministries and the bodyguard Waswa Israel. Sam Mukala accuses Pastor Jackson Senyonga of torturing him with his bodyguard around his church premises.
Supposed to commence today, the 21st day of August 2023. However, we have been informed that the trial judge is not around and unable to proceed. And we have been given the 23rd of October 2023 as the date on which the hearing is supposed to commence. I've heard from the lawyers of Pastor Senyonga, who have informed us that they have filed their reply, which we are yet to receive at our chambers. And we shall file a rejoinder to the same, and we shall be ready to commence the hearing on 23rd of October.
Your name once again, sir?
Semogere Sam.
Thank you.
The victim, Sam Mukala, talked to the media.
Hello, I'm called Sam, and the reason as why I'm here, I was tortured in 2018 by the security team of Christian Life Church of Pastor Senyonga. And the reason as why I came in, I filed this lawsuit. Actually, I did not receive justice, and I want these people to compensate me for the damages caused. Actually, I can't tell. It is court to decide the actual amount of the money that should compensate.
Okay.
How's the situation now? Because we are told.
Actually, at this point, I'm still not okay. I'm always going to hospital, so the expenses are ever increasing. Yet I cannot afford the expenses.
Mukala alleges that in 2018, while he had gone for prayers at Christian Life Church Ministries Kavule, he was tortured by the bodyguard of Pastor Jackson Senyonga.